Most people in Wisconsin will never hire a personal injury lawyer in their lifetime. And when they do, it's usually after something stressful, a serious car accident, a workplace injury, or maybe an accident on the farm. For many people, calling a lawyer for the first time can feel intimidating. You might be wondering, what am I supposed to say? What if I leave something important out? Are they going to start using legal terms that I don't understand? Am I going to be pressured to file a lawsuit right away? And how much is this going to cost? Those are completely normal questions. Most of the people who contact a personal injury lawyer have never done this before. Now, let me start by saying who this video is for. This video is for people or family members of people who have experienced a personal injury in Wisconsin as a result of someone else's fault. Something that required medical care, caused time away from work, or created ongoing physical or financial stress. This might be a car or truck crash, could be a workplace injury depending on the facts. It might be an injury from tripping or slipping on an unsafe property. It could also be things like dog bites, fires, and chemical exposure. These situations often involve medical treatment, insurance claims, and legal questions where having guidance can be very helpful. If you're in this situation, you probably have questions. Now, who is this video not for? This video is not for people who have not sustained a personal injury. It's not for people who have only sustained property damage. This video is not for people who have been victims of medical malpractice. And this video is not for people who were injured because of their own fault or maybe nobody's fault, such as hitting a deer or falling asleep at the wheel. In this video, I'm going to walk you through what it actually looks like to hire and work with a personal injury attorney in Wisconsin, what the first conversation is like, how fees work, and what typically happens after that. So let's start with step one, the initial consultation. The first step in hiring a personal injury lawyer is usually an initial consultation. In personal injury cases, that consultation should be free. You could talk to multiple lawyers to find the one that's the best fit for you. Your consultation with a lawyer's office should be confidential. This means that they should not share what you talk about with anyone else. Be sure to ask the lawyer if your call with them is confidential. Now, you may be pressured to sign a contract while you're still on the phone with that first lawyer. Make sure you find the lawyer and law firm that is the best fit for you before you commit to anything. Now, during that initial consultation, the lawyer or someone at the firm will ask you to describe what happened and gather some basic information. Typical topics include things like when and where the accident happened, who may have been involved, what injuries were sustained, what medical treatment you've received so far, and whether you've already spoken with any insurance companies. As you describe what happened, the lawyer may ask some follow-up questions to better understand the details. For example, where exactly did the accident occur? County, city, intersection, travel lane, if you know those things. Was law enforcement involved, and who? Was it the police, the sheriff, maybe the highway patrol? Did you receive medical care that same day? And do you know who owns the vehicle or equipment involved in the accident? Have you spoken with an insurance adjuster? Did you give a recorded statement? Were you dealing with injuries and illnesses that may have predated the crash but were made worse or aggravated because of this accident? These questions aren't meant to put you on the spot or to embarrass you. They simply help the lawyer understand the facts to make sure that they can help you or point you to someone else who can. Now, one of the first questions you'll be asked about is who was involved, including other drivers and insurance companies. One reason for this is to check for something we call a conflict of interest. Law firms and lawyers have ethical obligations that prevent us from representing both sides of the same dispute. You want to make sure that they don't represent one of the parties in the accident on that or an unrelated matter. So if someone involved in the accident is already a client of the firm may not be able to represent you. But most of the time there is no conflict. But if there is, that lawyer may be able to help guide you to someone that can help you. Now, the purpose of that consultation really has two goals. First, it helps the lawyer understand what happened and decide if they can even help you. Second, it helps you decide whether you want that lawyer and that law firm representing you. If you have documents like crash reports, photographs, insurance information, maybe medical bills and paperwork, those can all be helpful to have available. But don't get worried if you don't have everything organized before you make that first call. That consultation is simply a conversation. If you'd prefer to meet with a lawyer in person or use Zoom or video conferencing, the lawyer should be able to accommodate that. Make sure that that first consultation is at a time and a setting that is comfortable to you. Now, number 2, let's talk about how personal injury lawyers are paid. One of the biggest questions people have is simple. How much does it cost to hire a personal injury lawyer? Most personal injury lawyers in Wisconsin work on what's called a contingency fee. That means you generally don't pay the attorney's fees up front. Instead, the lawyer is paid a percentage of whatever is recovered. If there is no recovery, the lawyer doesn't recover a fee. Now, what does recovery mean? In this context, a recovery means the money that is obtained as compensation for the injury. That money might come from an insurance settlement, a negotiated resolution between the parties, or a verdict if the case goes to trial. Recovery may include compensation for things like medical expenses, lost income, future medical care, reduced earning capacity, pain, suffering, and disability. Now, I want to talk a little bit about how contingency fees actually work. The key features are fairly straightforward. There are no attorney's fees paid up front. The lawyer receives a percentage of the recovery if the case is successful. And if there is no recovery, there is usually no attorney fee. This system allows people to pursue legitimate injury claims without having to pay legal fees out of their pocket while they're already dealing with medical expenses and lost income. Now, I want to talk about what we call case expenses, because some cases also involve expenses such as copies of medical records, expert retainers, deposition transcripts, court filing fees, things like that. See, these are costs that are often advanced by the law firm or lawyer during the case, and then those get reimbursed out of the recovery if there's a successful case. A good lawyer will explain the fee agreement clearly and answer any questions you have before moving forward. Now, if you're wondering what not to say to a personal injury lawyer, let me talk a little bit about that. Some people worry about saying the wrong thing when they speak with a lawyer. The most important thing is just to be honest. You don't need to remember every detail perfectly. You don't need to know who was legally at fault. And you don't need to know what the case might be worth. But it is important not to hide or overlook facts such as prior injuries, or accidents or claims, or any conversations you've had with other parties or the insurance companies. A lawyer can work with difficult facts, so don't hide them. What causes problems later are surprises. Let's talk about step 3, which is sort of that early case evaluation and investigation. So once you've hired a lawyer, the law firm begins evaluating and investigating the case for you. They'll help gather medical records, medical bills, police and accident reports, insurance information, photographs, video, and other documentations of the accident or crash. Now, one of the early steps involves sending preservation letters to make sure that important evidence isn't lost or destroyed. Depending on the situation, that it could include things like vehicle data, maintenance records, accident reports, dash cam footage, and electronic records. Lawyers are also trained to look for other sources of information. For example, a business near an accident scene sometimes will have security cameras that may have actually captured the accident. If that footage exists, it may need to be requested quickly before it gets deleted. You see, those cameras generally get rewritten over within weeks or a month of the accident if someone doesn't request preservation of that footage. That's why it's really important to talk to an attorney as soon as possible. Now, when it comes to communicating with insurance companies, once a representation begins, once you hire a lawyer, that law firm will typically notify the insurance company that they're representing you. The insurance company is informed that a claim is being made and that all communication should now go through that lawyer rather than contacting the client directly. This helps protect clients from unnecessary pressure or confusing conversations with insurance adjusters. One of the more important jobs a lawyer does is to identify all potential insurance companies and policies that might possibly provide coverage. If someone has more severe injuries, it may take multiple insurance policies to provide the full compensation that you deserve. One of the other things that the lawyer is going to do right away is identify any important legal deadlines. Early evaluation involves identifying when a legal action needs to be brought. This may include things like the statute of limitations. That's the deadline for filing a lawsuit. There may be other notice requirements that could also affect the case, such as if a municipality is involved. Identifying those issues early on helps ensure that important rights are protected and not inadvertently lost. Now, in Wisconsin, the deadline is typically 3 years from the date of the accident or injury, but different rules can apply depending on the circumstances, so don't wait to talk to an attorney. Do so as soon as possible. Now, I want to talk about what your role looks like as the client in this process. See, once the legal process begins, your main focus should be on your medical treatment and getting recovery. However, there are a few ways that clients can help that process move a little more smoothly. Number one, make sure you're continuing the treatment recommendations of your doctors. If they make referrals to other specialists or providers, make sure you follow their advice. Keep your lawyer or the law firm informed if anything changes. For example, if you begin new medical treatment, if you start seeing a new doctor or specialist, or you experience any changes in your job situation. This could include missing additional time from work or returning to work with restrictions. These updates help your lawyer understand how the injury is affecting your health and your work. You may also be asked to provide documents such as medical bills, insurance correspondence, or employment records. Clients are generally advised to avoid discussing the case publicly or on social media. Insurance companies sometimes monitor public posts, and comments taken out of context can create confusion about the injury. But be sure to talk to an attorney before you delete any posts that you've already made. Now, I want to talk about step 5, which is what we kind of call the settlement phase. So once medical treatment has progressed enough to understand the full nature of the injuries, the case will generally move into the settlement phase. At that point, your lawyer may prepare a demand package, which sort of summarizes everything that happened, the injuries involved, and the damages being claimed. That information is sent to the insurance company so that that claim can be evaluated. Sometimes a claim can be resolved through negotiation without even filing a lawsuit. In other situations, filing a lawsuit becomes necessary to move the case forward. Even when a lawsuit is filed, most cases still resolve long before a trial. A good personal injury lawyer prepares every case as though it may eventually be presented to a jury. You see, when insurance companies see that a case has been investigated thoroughly and prepared seriously, it often leads to more meaningful settlement discussions. Those claims just get taken more seriously. Now let's talk about step 6. What if a lawsuit is filed? Sometimes it is necessary to file a lawsuit, but that doesn't mean the case is automatically going to go to trial. Sometimes we have to file lawsuits simply because a legal deadline, such as the statute of limitations, is approaching, and maybe you're still treating. In other situations, insurance companies may just refuse to disclose policy limits or provide enough information to allow your lawyer to evaluate the claim fully. In cases where a non-attorney insurance adjuster is holding up settlement, filing a lawsuit can actually help because now the insurance company has to hire lawyers who may then tell the adjuster to rethink their settlement position. Filing a lawsuit allows the case to move forward in the court system and allows both sides to exchange information and question witnesses. The litigation process can involve things like written discovery, depositions, expert evaluations and reports, and additional types of investigation. Your lawyer's job is to prepare you for each step of that process. And even after a lawsuit is filed, many cases still settle before trial once both sides have a better understanding of the evidence. Now, good communication is super important for any legal representation. Now, that usually includes updates when important developments occur in your case, an honest evaluation of your case, and the availability to answer any questions that you may have along the way. Now, there may be periods of time where things seem kind of quiet, such as when medical treatment continues. Your lawyer probably has a team of people helping them. I do. Other lawyers, paralegals, and legal assistants, they can often help answer your questions and keep you updated even when the main attorney is not available. Most cases go through different stages, with some that are busier than others. When a client's case is being prepared for trial, that lawyer is likely way more busy working on their case at that time. But when your case gets ready for trial, your case will be the focus of their attention. That's very normal in personal injury cases. Hiring a personal injury lawyer in Wisconsin can be an intimidating process if you haven't done that before. But don't worry. That's a perfectly normal feeling. If you'd like to contact my office to schedule a free consultation, just use the number on the screen. If you'd like more information on the process of hiring a Wisconsin personal injury lawyer, just watch one of the next videos on the screen. And if you'd like to understand more about how these cases work, the next videos help explain that.